Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. we bring in immigration updates. Emily, now things are a little bit uncertain in the administration now, and things are going around like crazy in the Washington, D.C. There are too many speculations on what would the new administration will be. I just want all the audiences to know that the new administration will be in only on January 20th. So until then, no matter what, Trump is the president. Now, there are a lot of speculations on what the Biden administration wants to do, can do, will do, and what is expected in the nearby coming. So I'm going to go through some of the rumors that have been filed, that have been going on, and I expect you to answer those questions. Emily, we have approximately 100,000 green cards that came from family immigration to the business immigration. There is a rumor that says that Biden, because the Democrats, wanted to pass a bill that will give the family immigration back to the family immigrants rather than giving it to the employment-based. If the Biden administration comes into power, can he give it back to the family immigration instead of giving it to the business immigration?
No, I don't think that's anything that he could do based on his own authority.
So it has to come from the Congress, and Congress is not expected to do anything, at least in the next near future. It's because it's a divided Congress, and still, even if the Democrats won the 2 Senate seats in the Georgia, they still don't have the majority, the 60 votes required to pass the legislation. So you do not expect that to happen at all. And what about the removal of the per country limit? Can Biden administration take up the removal of the per country limit?
No, that also has to go through Congress.
What about the H-1B? The wages have been increased right now. Starting from October 8th, the wages started increasing because of prevailing wage. Can the Biden administration undo it immediately?
Not immediately, no. It would have to go through the whole regulatory process to eliminate that interim final regulation.
So it's going to go through a lot of process, but immediately you say no. Now, there are new regulations that are becoming effective on December 8th, Emily, wherein they have redefined the specialty occupation, and they said that for consulting companies, the H-1B should not be granted for more than 1 year. And they are becoming effective on December 8th. Can Biden administration immediately undo these things, though?
No, because it is going through the full regulatory process. He's going to have to go through the regulatory process to reverse it.
Emily, there is a rumor that is going on now. We have the vice president who is, partly Indian. Is there the people who are in line right now in getting the green card, especially in the employment-based? Do you see that they're going to get ahead in some way? There's a rumor going on. Can this administration do something by themselves without going to the parliament?
No, it all is set in Congress for that 7% cap, and that's really what has created these lines.
Can this administration increase the H-1B quota without going to the parliament or Congress?
Nope.
Now let's go to some of these things that what will happen to the H-4 EAD? I mean, Trump administration wants to take it off, and he hasn't yet proposed any regulations. What will happen with the Biden administration, Emily?
Yeah, I would expect that they would continue the H-4 EAD, assuming that the Trump administration does not get any final regulation through before January 20th, which is very unlikely since they haven't even proposed it yet. I don't see the Biden administration moving forward with that regulation to eliminate it, so it should stay as is. We do have a court case on that, however, that the Biden administration would have to defend the H-4 EAD, which is the opposite of what the Trump administration is doing. So it might come down to what the courts decide.
Emily, processing times of everything has gone up. 485 processing, 1 month ago it was like about 36 months. Now it's like 45 months. Every month it's going back by about 4, I don't know. Do you think that Biden administration might improve a little bit on this one?
Yeah, this is an area where we could see some improvement because he does have executive authority over the Department of Homeland Security and in turn USCIS. He can push USCIS to improve their processing times.
Emily, recently Trump administration has proposed that the H-1B lottery should be only given to the highest paid employees rather than more talented or better equipped with. It's highest paid. Will the Biden administration go through that, or he may put a block on that one?
So I think that assuming that the Trump administration does not finalize it, I don't see the Biden administration moving forward with that.
The consular processing have been gone very much appointments even before the pandemic, Emily. Assuming that we have this vaccine and everything goes through clear, do you expect anything to come, processing times to come down in the consular processing though?
Yeah, I think that should improve as well, because part of what created all the problems with consular processing was that idea of extreme vetting, the public charge rule, and all these additional things, asking for the social media handles and all that in the DS-160. So hopefully that's something that he can address to kind of make it less burdensome to apply for the visa and get through the process.
And what about the filing fees increase? Now that's in the court right now, where the court blocked it. Assuming the preliminary injunction has been taken off, what would Biden do? Will he not increase the filing fees, or will he go through increasing the filing fees?
I don't think he would go forward with this particular regulation, because it increases filing fees for citizenship. For asylum, it actually creates a filing fee, and I think those are the areas where the court really did not like this rule. So I would expect they'll start a new process of fee increase, because the agency does need a fee increase. They can't survive on fees that were set several years ago, and they were even behind on increasing fees this time around.
Emily, when a student comes into the United States, they will be given a 994 with a duration of status. So right now, the proposal of the Trump administration is to take off the duration of status. That means that every time they change university, they apply for OPT, they have to file an I-539, which the processing time is 15 to 18 months. What do you think this administration is going to do with this duration of status? Means nowadays, if they have to apply, F1 comes in, they join a university, they want to go to a different university, they just change the service system, they want to apply the OPT, they just apply for the OPT EAD card, STEM extension, they get the STEM extension. They don't have to go through filing an I-539, extending the F1 every time. And now the Trump administration proposal is every time they have to do it, they have to file an I-539 where the processing is 15 to 16 months. What do you think of this administration is going to do?
Yeah, I would expect they won't move forward with that regulation, assuming that the Trump administration is not able to finalize it before January 20th. So hopefully that one will go away.
Emily, what about this travel ban for the work visa, especially for the H-1s and L-1 visas? The travel ban is there until January 1st of 2021. We don't know if Trump administration is going to extend it. For sure, this administration is not coming in until January 20th. So if the travel ban is extended, what do you think Biden administration is going to do?
I think Biden would lift the travel ban. That is one of the areas where he clearly has the power, because Trump obviously has the power to create these travel bans, at least according to the Supreme Court. And I would expect Biden would lift those.
I just want people to understand that there are certain authorities that the administration has it. There are certain authorities, they have to go through the Congress, which, in the English system, we call it as Parliament. And the Parliament is not in Biden's administration right now. It's been divided between Republicans and the Democrats. The Democrats hold advantage in the House, which is a lower house, which is called as the House of Representatives. When it comes to the Senate, though, it's even though the elections are not decided, it seems that the Biden administration it doesn't look like they're going to get the majority. Because of the rules of the internal rules that they have, the Senate, if any bill has to be passed, unless everybody accepts it, they need to pass by 60 votes. That's called filibuster. It doesn't look like either party is going to have the filibuster at all. So if something has to go through the Congress or the Parliament that we call in English system, it doesn't look like anything is going to pass through. If you consider that, Trump administration was unable to get through any of the major immigration legislation. They couldn't get it. All the things he passed it by the executive order or regulations. Some of those executive orders which were done by Trump administration, by the Obama administration, Trump tried to undo. For example, Obama administration has done the DACA kids, where the kids that came into the United States when they're under 15 years old, have completed their high school. Obama has given them an employment authorization document. The Trump administration tried to undo it, but the courts blocked it. So there are a lot of hurdles that we will notice when this administration comes in. Certain things they don't have an authority, certain things they have to go through the regulatory process, which takes a long time to go through it. And certain things are executive order, like the way Emily has said, the travel ban kind of things. They can be undone more easily though, but the regulations have to go through very rigorous things. It may take a long period of time. And don't assume that this administration is going to be magical wand. As soon as they come in, they will do something very good. I have seen Biden before. And let me tell you one thing. When Biden came into power as a vice president, we expected a lot of things to go through very smoothly in immigration. But later on, we called, when compared to the Bush administration, we called Obama's administration, which Biden was part of it, he was a vice president, we call these two people as the deportation kings. So there are certain things that are getting pointed out that the deportation might go up to, because he wants to increase the number of judges and a lot of other things. Yeah, the deportations may go up, but that's not very much concerning to the employment-based. As far as the employment-based is concerned, we have gone through all the question and answers. You can go back to the front of the video and to listen to what could be done, what cannot be done. Anything else to add on, Emily?
Yeah, and I think if you look at, these past few days, the Biden transition team has kind of put out what their plans are for the first 100 days, and it does involve immigration. Unfortunately, none of it is related to employment-based immigration. So their targets are more dealing with stopping, building more border wall, dealing with the Remain in Mexico or the MPP program, trying to fix the asylum process, trying to bring back DACA to its full extent. Those are the things that the Biden administration is going to be focused on from an immigration standpoint in the first 100 days. I don't see many major changes to employment-based immigration other than possibly lifting the travel bans.
Emily, on the CAP subject, H-1B lottery, especially the people who are on the OPT and STEM extension, they have to go through. One is a prevailing wage thing, which is a tough deal, and then there's also who is the highest wager is going to get the H-1B. What do you advise people who are students right now? What should they do? Well,
I would first remind you that this change in the lottery process is just a proposal at the end of the administration, so it may not actually move forward. If it does move forward and is actually finalized, I would expect lawsuits to be filed, because there's nothing in the Immigration and Nationality Act set by Congress that gives the president the power to make this type of change. There's nothing in the H-1B law that is passed by Congress that requires salary to play a part in the adjudication. Yes, there's a prevailing wage that must be met. That's set in the law. But there's nothing talking about giving H-1Bs only to the best and the brightest. That's not actually what it was created for. That's what the O-1 visa is for. So really with this regulation is trying to take the H-1B beyond what Congress intended. So that regulation, I think, would be likely shut down by a court. So hopefully, I think the main thing will just be the uncertainty as we're going into a new year and getting ready to prepare those filings in March during the electronic filing window. It may be kind of a lot of back and forth to understand what the actual requirements are at that point.
Emily, I want to discuss about the regulations that are becoming effective on December 8th, the regulations with regards to more strict scrutiny on the specialty occupation and also on the consulting companies getting only 1 year H-1B. They are becoming effective on December 8th. What is your theory on it?
So yeah, the comment period just closed on that on Monday, and a lot of people came out against this change. So if the administration follows regulatory procedure properly, they shouldn't be moving forward with the regulation. But if they do, I would expect, again, another lawsuit's going to need to be filed in order to block this regulation, and it's very likely to be successful because, again, it is changing what Congress intended. There is a set definition in the Immigration and Nationality Act for what a specialty occupation is, and they're narrowing the definition of specialty occupation beyond what Congress intended. On top of that, they're not dealing with any of the unintended consequences of this 1-year extension rule for third-party placement. It's not just consulting companies that do third-party placement. You're talking physical therapists, doctors.
Most of the hospitals cannot even hire any doctors directly. They have to go through the third-party placement only.
Exactly,
especially
teachers. So we have all these other industries that are going to be negatively impacted by this rule that doesn't really do anything to solve a problem. It's just meant to target consulting companies. But unfortunately, the negative impact to others was not considered in that. So I think it's likely to be blocked by a court, but we'll have to wait until December, possibly into January, for that to happen.
Emily, last but not the least, we're not going to say what the election results are. You're not an expert, I'm not an expert, but assuming that this is the end of the Trump administration until January 19th, though, what more damage he can do for the business immigration? Because we know he doesn't like immigrants. Mm-hmm. So what more damage he can do?
Yeah, I think he could extend the travel ban beyond December 31st.
Okay.
I think that he can, and I think Stephen Miller's made it clear, they want the visa application process at consulates to be even more difficult, more scrutiny on that, and we're already barely able to get an appointment at this point, so that's likely they're going to try to slow down the ability of people to get their visas to come in. More things to try to curtail H-1B work visas and the different kinds of work visas. I think they'll keep doing what they've been doing so that it'll be harder for a Biden administration to come in and change it right away.
Stephen Miller, he has been portrayed in a movie called Borat. Have you seen it?
No, I haven't.
He's been dressed as a Ku Klux Klan person. So that guy is in charge of the immigration, so you can expect what things can come through. Lots of questions with regards to, some question is that, hey, can the Biden administration, Prashant is asking from Facebook, can he make priority dates current? No, he cannot just make every priority date, especially employment-based priority date. He cannot make current. He has to go through the Congress, which we already discussed about what that means.
Morale from Facebook wants to know what the status is of the various lawsuits trying to block the wage rules and the specialty occupation definition. So at this point, there has not been a lawsuit filed on the specialty occupation regulation change, and that's because that regulation has not taken effect yet. We haven't actually been harmed yet. So usually you have to wait until a harm has occurred before you can file a lawsuit on that. On the wage rule, several lawsuits have been filed. I believe some preliminary injunction hearings have been going on. So hopefully within the next few weeks, we might have a decision on at least the preliminary injunction to block that.
Question that come out, will the premium processing filing fees go down with the Biden administration? The answer is not expected, because this was passed mostly by the House, which was overwhelmingly Democratic, and it was passed through both parties. So I'll be very surprised if he's going to reduce the premium processing fees.
Question from YouTube. My wife has a pending EB-2 I-485. Her employer's in Texas, but she's working remotely in Washington. Can that cause a problem for her green card? Well, for the green card process, even though you filed the 485, that application is for the future permanent role that she will move into when she actually receives her green card. So as long as she's maintaining her current status, whatever that is, and complying with those requirements through this remote work, when she actually receives the green card, it should be for the job offer in Texas. She may have to move to Texas at that point, but as of right now, it should not impact the pending application.
Sunil from YouTube has asked a question, when can we expect the receipt notices that we filed in October of 2020? They're taking a long time. We are getting the receipt notices that we filed in the Phoenix Locksbox, but not in the Louisville, Texas box. They're backlogged very, very long. There are, based on the address we file either in Phoenix or in Louisville, Texas, especially if it's a downgrade application, there's only one address, it will go to Louisville, Texas. We haven't been receiving yet much. We may probably be receiving by the end of this month.
Ahmed from Facebook applied for the adjustment of status in EB3 on October 1st, and he wants to know how long should it take to get the EAD. Right now, EAD processing time is probably a good 6 months. I would expect it to be longer due to the delay in receipts and because of the high volume of filings that happened in October. It might be closer to 8 months.
Srinivas Bollam has this question. He has a perm approval under EB2 category. Can he file for EB2 and EB3 at the same time using the same perm application? Absolutely you can. Absolutely. No problem, you can. You can do it, absolutely no problem with it.
Yasaswi from YouTube has a perm that was filed last October of 2019, and it's still pending with the Department of Labor and wants to know what is the normal processing time. Yeah, they're not taking that long. So normally perm applications are taking maybe 5 months after filing, unless it's audited, then it may take a few more months to process.
Sai Shah from YouTube has this question. He is in United States. Can he book a emergency visa appointment to go to India and come back in? Well, that's a very tough question. You're asking for an emergency, saying that you want to go to USA. You're already in USA. So what's the emergency for you? It becomes a very tough question. There got to be something peculiar in this case that warrants the consulate to give an emergency, because you're already here. What is your emergency? Yeah, I want to visit my mom. Well, if you want to visit your mom, you're going to India. There is no prohibition from the US government. So if you want to come back, that is the emergency. The emergency would be that you want to go to United States, but you're already in United States. So there got to be some novel idea that has to be there, novel reason that should come up where you can get an appointment in emergency and go there and come back.
Salai from YouTube wants to know if they will reduce the premium processing fee for H1s and I-140s. I already got that one. Yeah. All right. Aswar from YouTube wants to know, I-140 petition was filed for a project manager position, but now the title is project leader. Job duties are the same. Will it be an issue for filing the 485? If it's just a simple change in the job title where nothing else has changed, it should not cause an issue.
Question from Rakesh. Is L1B applying available right now? Is there a ban on it? Rakesh, you can still get the L1 visa to be approved. You are not eligible to apply for the visa stamping in India. But as far as the applying the L1B to get an approval, you are still eligible. And you can book an appointment anytime after January 1st. With the L1B, not because the travel ban is only until December 30th of 2020.
Amit from YouTube wants to know, when will the U.S. consulate in India open for regular stamping appointments? You know, no one can really answer that question because it all is based on the issue with the virus situation in that location. I mean, you know, we're here in Houston. We're obviously still wearing masks, social distancing. We're under a stay home, work safe order where we're still not allowed to be fully in the office 100% of the time here. So assume that's happening around the world, and employees of the consulate, the consular officers, are likely in that same situation. They're not going to be able to go back to 100% operations until we have a vaccine and it's actually causing an improvement in the situation.
Question that comes is, how long does it take for an EAD, adjustment of status based on the employment-based EAD, to come through? Well, before the pandemic, it was taking about 8 to 10 months. After the pandemic, though, it may take a little bit longer time. We don't know how much. Hopefully, the new administration can come and change the policies to make it very faster. I have seen, though, when Bush administration came in 2000, oh man, the dates moved like anything. I really love Bush administration in the sense that at the time of Clinton administration, it was taking 48 months to get the adjustment of status adjudicated when everything is current. When Bush came in, he gave 3 months for the administration to reduce the time. And guess what happened after 3 months? Nothing got reduced. You know what Bush did? He fired all district directors, and he didn't fire them on the same day. He fired them. You're all fired 6 months from now because you didn't do the job. Guess what happened? In 6 months' time, the processing time went from 48 months to 2.5 months. We were begging the immigration, don't adjudicate fast. We can't collect certain documents in 2.5 months. We were begging them to not, because there are some documents we need to collect, especially marriage documents, living together documents. We can't collect the documents. Don't adjudicate it within 2.5 months. We begged them from 48 months to 2.5 months for the adjustment of status. So if this administration wants to do something, they can do it. I have seen Bush administration doing it. The processing time went so. There were adjustment of status interviews on Sunday morning. Well, that's a church time. Saturday evening, 6 o'clock. 5 o'clock in the morning Saturday. Man, oh man, things came out. If this administration wants to cut down the time, that they can do it, but we don't know if they want to do it.
I have a couple of questions about biometric delays for I-539. So Shivant from YouTube has an H1 extension that's already approved, but the I-539 has been waiting for the fingerprinting for a month. And Shivani from YouTube has an L2 extension for her son, also hasn't heard anything in a month after trying to reschedule that appointment. So the biometrics appointments are very hit or miss. It's all based on what's going on at your local office. They have to spread out the appointments more to allow for social distancing and cleaning in between. So appointments are few and far between. Plus, they're still working on the backlog that's been created since they canceled all those appointments going all the way back to March. So I've had a couple recently where we filed the applications in May and they got the appointment in October. If you just filed a month ago, it might be a few months before you get the fingerprint appointment, and the reschedules are taking a long time as well. You kind of go to the back of the line when you do a reschedule.
Adyan from YouTube has this question: can a EB-5 limit of 900,000 be reduced to 500,000? Now that went through the Congress, which is, in Parliament, we call it, it's Parliament, they call it as Congress here. It went through the Parliament, so it has to go through the Parliament to reduce it. The chances are very, very slim that will happen. And it's not in the proposal of the Biden administration to reduce that limit to 500,000.
George from Facebook wants to know, can the Biden administration remove the requirements of H4 EAD biometrics?
Yes.
So yeah, they could. I mean, that biometrics was actually not done per regulation. It was just an update to the form, the I-539 form. So
Good question.
That could
I mean,
easily be done.
the Biden administration can do it. Not only if they do it, though, the processing times might drop down significantly for a lot of applications. Yes, that's a good proposal. I think so. We need to, once this administration comes in, we need to recommend that to the administration to reduce it. Depends on who they will appoint as the USCIS chief, and we should lobby it to get that thing removed. There are a lot of things that came in that should be removed. The public charge rule, even though it has to go through the regulatory process, as we described before, if we can avoid a lot of these things, the processing time will go down, especially in the consulate, the Facebook, the social media thing. All these things, did they catch anybody? I mean, if somebody is a terrorist, would they say in the Facebook saying, oops, I am a terrorist. Here is my gun, here is my AK-50, I don't know, whatever that they have. We haven't seen that if, the amount of resources the government is putting in, did they get any reward for those things as compared to if they secretly do it? I mean, they find out who the people are applying and put the resources there. They would be much better off. That's my opinion. If this administration comes into it, they may do it, and they can do it if they want to. Some of those things requires regulations to be changed. As Emily was pointing out, the I-539 biometrics, it was just an update on a form. I mean, they can update a form in the next 1 week and get that thing reversed, though.
Yeah, another one is the deference to prior approvals. If they bring that back, that will drastically improve processing times as well, because right now they're looking at every single petition or application on its own, regardless of whether you were approved 3 years ago or for the last 10 years over and over again. So that would speed up the processing time as well. Sorab from YouTube wants to know if the no blank policy applies to I-765 applications. So as of right now, the no blank policy is not really being applied to most immigration forms. It seems to be more on the asylum applications. It is a proposal. It's kind of in the process, in the form instructions. They're going through several form revisions right now, and when we get new versions of the form, it's very likely that they will include the no blank policy in that. But as of right now, it's not being applied on I-765s.
Question from Ravi Sharma, that is there a chance that EAD and AP can be denied once the 485 application has been received? Well, there's always a chance, but I will tell you one thing. The chance of getting it denied once the acceptance has been done is very, very, very rare. They should approve it. I mean, if all the things are there. Sometimes if something is missing, maybe pictures are been lost, the passport pictures are lost, they may issue an RFE, but very unlikely that the EAD and AP will not be issued.
Raj from YouTube wants to know if any priority will be given to people who filed on October 1st versus October 30th. I'm assuming under the October visa bulletin for the adjustment of status. I mean, applications are processed first in, first out, but when they're all filed in the same month, they're all filed basically at the same time. And on top of that, you still need the final action date to become current. So ultimately, it's the final action date and your priority date that determines your processing time more than filing on October 1st versus the 30th.
Kishore is asking question, what will happen to this 944 form? Will it be revoked? Kishore, we did address that question in the initial stages, in the first 15 minutes of our video about the public charge rule. What Emily pointed out was that the public charge rule was done through the regulatory process. So if the administration wants to undo it, they have to go through the regulatory process though. The only exception that is there is that, and there are some court cases pending, if the court rules otherwise, then it's a different issue. But if the court doesn't rule that it's illegal, then the Biden administration have to go through the regulatory process. To tell you that the regulatory process at a minimum, I mean, it will take about 6 months. And don't assume that when the Biden administration comes in, he will immediately go into the immigration law and say, hey, this is all wrong, this is wrong. They have a lot of other priorities. We don't know if this administration is going to give top priority to immigration and put all the things out forward. We don't know yet whether they're going to give the top priority.
Prasad from YouTube wants to know if there's a way to check the PERM application status. What is the website? For PERM, there is no public website where you can enter your case number and get the case status. Your employer would have to log into their PERM account to get that information, or the attorney can do that as well. Mohana wants to know, can I move to a different employer in a different location after 6 months with my current employer, after 6 months of filing the adjustment of status? So I would say it depends on if your I-140 is approved. So if you did a downgrade situation, I think that would you would need to make sure that your H-1B is taken care of and may want to wait until the I-140 is approved before you attempt any kind of AC-21 change. Assuming the I-140 is approved, I do think that as long as the job is in the same or similar occupation, you could submit a supplement J to move the job to a different location with the same employer, just like you could move to a different employer.
Lots of questions on coming on the Biden administration. What they will be doing is, especially the question from Kamal Gandhi from Facebook is that Senate 386 bill, what's going to happen? As pointed out, that it is a Senate bill of 386. So Biden administration has nothing to do with the bill. It has to pass through the Congress, then only it will come to the Biden administration to sign it. I for sure know that based on his policy, if it comes to his table, he's going to sign it. But remember that even Trump wanted to sign that one. There's no objection from Trump. The Senate never went through. It didn't went through the Congress. So it is in the Congress. It's stuck in the Congress. It has to be passed in the Congress for it to hit the president's desk.
Mahesh from Facebook wants to know, can an H-1B employee who's also a Canadian permanent resident live in Canada and work for a U.S. employer in Canada during the pandemic? Well, if you live in Canada, you don't need an H-1B. You're not an H-1B employee. You can work for any company that Canadian law allows you to work for, including a U.S. company remotely.
One other question on whether CSPA, Child Status Protective Act, is it going to, does this administration can do anything, can it be a little bit more liberal on implementing that? Well, that comes from the law that's passed in the Congress.
There's one thing they could do,
okay,
and that is change their policy on the two charts and allow us to use the filing date chart to calculate age,
okay,
not the filing date chart.
Okay, Emily, I want you to explain it more clearly what you're saying. I got the point though, but I want you.
Yeah, so with the Child Status Protection Act, the idea is the child's age is frozen when the 485 is filed so that they don't age out. So if they're under 21 on the day of filing the 485, their age should be locked in and they are able to adjust with the family. That all got changed when we created these two charts, because now we have the filing date chart that allows you to file earlier than when a visa actually becomes available. And after those two charts came in, there's a specific policy memo that the government decided on that says we are not going to use the filing date chart filing as when the age is frozen. So you're still allowed to file under the filing date chart, but when they're calculating age for Child Status Protection Act, it's calculated based on when the final action date finally becomes current. So for all these people that just did these downgrades, it may be some time before the final action date actually becomes current, and a child could age out in the interim even though they have filed the 485. So that is something that he could do. I think it's probably very low on his radar. I doubt he even knows what it is.
I think, Emily, it will depend on who he appoints,
yeah,
though. It will depend on if the immigration chiefs are appointed and they have the will, though. Biden is not going to come and interfere into all these little bitty things, though. It depends on, like the way Stephen Miller, I mean, he's just, I don't know what to say. Mm-hmm. He's just an anti-immigrant. They put them in as an immigration chief or the advisor. Now here, if they keep nice people in there that understands the thing, though, especially with the Child Status Protective Act, I mean, it's a very depressing thing to have the kid left over and all the family gets through. And I have one a girl who called me on the conference call, and she tells me that she's 23, she's left out. Her two siblings got it, her parents got it, she's left out. Is really crying. It's a very terrible thing to happen for a 22-year-old kid that she didn't went through. I mean, these are the things that we want you to, when this new administration comes in, we want you to write a letter to the congressman. They can write to the administration, and this administration might listen to your stories much better than the previous administration, especially on the Child Status Protective Act. I and Emily are going to do one special session. It'll be a 10-minute session, especially just on Child State Protective Act. We'll go through all the things one time and release it in the next 2 to 3 weeks, Emily. A good point that was brought out, and thank you for reminding me about that they can change in the filing dates, though.
Yeah, that would definitely be a big help to a lot of people.
Manish has this question, hey, how can they do for DACA people? Why not CSPA people? Mahesh, I want you to be very careful, though. Whenever you're approaching the Congress, whenever you're approaching anybody, though, never say that they are getting it, I am not getting it. Just request them that I should be getting. Don't always try to undermine other people who are getting benefit. It's not a proper way. The congressman won't feel very good. You can say that, the DACA people are very nice. They've been protected. I would like to have my own kids also to be protected. If you go in that fashion, that's fine. Hey, they should not be getting, my kids should be getting. Don't do that. You're not going to get a good benefit if you do that.
Sia Shah from YouTube is on H4 and wants to travel to visit her father and come back, but needs a visa stamp and wants to know if she's going to be able to get an appointment. The interview appointments, I think they're mostly scheduling for February and March at this point, and there's no guarantees that they will keep those interview slots. They could always cancel and reschedule, just like they did throughout this year due to the COVID-19 situation. So it's very possible if you do travel, you may end up stuck there waiting to get your visa.
Emily, these questions on the visa bulletin, though, you said that when the filing dates were being used in the month of October, though, historical, they did also in November. In some cases, they did in December and also in January, though. A lot of people are asking the question, what do you expect? They're going to still remain the same in December? Going forward in January, what do you expect in the December visa?
Yeah, the filing date chart is unexpected to change at all. If anything, it might be next summer after they see how many downgrades and how much demand there is based on the actual filing. So don't expect the filing date chart to move at all. I would expect that in December we'll probably still be able to use the filing date chart. Every time we've been able to use it in October, we've been able to use it in November and December. So hopefully that will continue. But really it's only the final action dates that move over these months.
Narendra Babu has this question, is the end client letter absolutely necessary to get the extension done? Narendra, at this point of time, though, before December, if you file your application before December 8th, though, it's not mandatory. We will be able to get the approvals more easily without the end client letter. But if you file an application after December 8th, though, they may require you to get the end client letter. Otherwise, they may not answer your question. They may not approve your case.
Fierce from YouTube says, Biden's website says they're planning to remove the country cap for green card processing. How likely is it to happen? So again, the president doesn't have the power to do that. So that may be part of his platform and agenda. He's for doing that. That doesn't mean he can do it alone. He has to get Congress to do it, and Congress has not passed any major immigration reform, not been able to pass S-386. That's going to have to start over again.
That's a small thing.
Anything that has to go through Congress, the chances of it actually happening are quite low.
And then let me tell you about the Biden administration. He wants a comprehensive immigration legislation to be passed too. If you look into the same website, he wants to have a comprehensive immigration legislation. So in the comprehensive immigration legislation, that would be one part of it. Now, if you look into the history of the comprehensive immigration, well, guess what? Nothing got passed since Rahul Reddy became an immigration lawyer. 25 years, I haven't seen any comprehensive immigration legislation passed through the parliament, through the Congress. Now, were there attempts made on it? Yes, there were attempts made in Clinton administration, then went through. There were attempts made in Bush administration, didn't went through. There were attempts made in Obama administration, didn't went through. While in Trump administration, there was never an attempt, serious attempt made through. But in the previous 3 administrations, each of them had 8 years. Clinton, Bush, and also Obama. I've been a lawyer in all these presidents, so I haven't seen any comprehensive legislation going through on the immigration. So when you look into the Biden's website saying that, yeah, I want to do this, I want to do this, yes, he may be right, but he doesn't have an authority to do it, though. It has to go to the Congress. So that's the reason we are trying to limit to see what he can go through the executive order that he can do, what he can go through the regulatory process. And I will suggest you again the things that we pointed out in the beginning of it. And I want to go through with you, Emily, what can go through with the Congress. And you have to tell, we already answered yes or no to this question. I want to tell you, one, going through the Congress is very unlikely. Going through the regulations is a burdensome but can be done. Going through the executive order or a form change is easier to do. So Emily, the family immigration, I will go through one and one, I'll go through the questions and I want you to answer which requires to be going through the Congress, which requires that it has to go through the regulatory process, which requires that immediate executive order or a form change. There's a rumor that the family immigration excess green cards have been allocated to the employment-based. If Biden administration wants to reverse that and give it back to the family immigration, how can he do it? Can he do it?
He has to go through Congress.
That means it's most likely no. He can't do it. What about removing the per country quota? Can he do it?
No, it has to go through Congress.
That means that he cannot do it himself. The answer is no. With regards to the wage increase reversal, though, that went into effect on August 8th, what does he has to do if he wants to reverse it?
New regulation.
So he doesn't have to go to the Congress, but it is new regulations, which if he has an intention, he can get it done in pretty soon, probably anywhere between 2 to 6 months he can get it done. What about the specialty occupation and definition change, the short-term H-1B approvals that are becoming effective on December 8th by the time Biden is not going to be president? If he wants to reverse it, how he has to go through?
Through a new regulation.
He doesn't have to go to Congress. Through the new regulations he can get to. What about the public charge rule that has instigated this form called 944, which is a big nightmare? If I were to fill that one, it will take a long time to fill my own application in there. What does the administration has to do?
He'd have to go through a new regulation.
He doesn't have to go to Congress. He has to go to the new regulations. If Indians were to be given benefit in the employment-based immigration, can he do it by himself? Does he have to go to the Congress?
Congress.
Okay. If he wants to increase the H-1B quota limit, okay, which is 65 plus 20,000, does he have to go to the Congress or can he do it by himself?
Congress.
Okay. The H-1B, H-4 EAD, if he wants to continue with it, does he need to do anything with it?
No.
So he just can do it by himself. Processing times are very longer. Does he have to go through Congress or regulatory, or he can do by himself?
He can do that by himself.
Okay, that's good. That's good. Any other questions? These are all the questions we went through in the beginning of the video. We want you to go through there. We answered yes and no. We explained why. And then Emily has now explained for each of these things, that do we have to go through the Congress, do we have to go through the regulatory process, or the administration unilaterally can do it without any problem. So please go through the first 15 to 20 minutes of it. It will give an idea, and then Emily now pointed out which ones to go through Congress and which ones that he can do it unilaterally.
Tejas from YouTube wants to know what happens if I travel outside the country before getting the advance parole. The H-1B requires a visa stamp. So I'm assuming that you have filed the 485 and filed an advance parole, and they're both pending, and that you're currently maintaining H-1 status with a valid I-94 and approval notice. If you exit while the advance parole is still pending, you have to get the H-1B visa stamp and come back in H-1 status to avoid abandoning your green card application. So you can go out and come back in on H-1B without abandoning the green card. However, your advance parole application is going to be denied because you traveled, so you'll have to file that again if you want the advance parole for your next trip.
Question from PP is that he hasn't filed the medical exams. He filed under EB3 category. Will his EAD and AP will be issued, or will it not be issued because he didn't submit the medical examination? EAD and AP will be issued, absolutely no problem. Medical is not necessary, especially if the priority date is not, the final action date is not current. I mean, there's no need for you to file the medical. So, but EAD and AP should be approved, should not have any problem. If by any chance the USCIS thinks that your priority date is moving forward, they may issue an RFE on the medical, or you can unilaterally submit the medical right now. It's called interfiling, I-N-T-E-R-F-I-L-I-N-G. Once you get the 485 receipt notice, use a word called interfiling and submit the medical, then it should go to your file.
Morale from Facebook wants to know, after December, is it safe to file an H-1B extension as a software developer if one has a non-IT degree? That could be problematic because with this new regulation, the degree has to be closely related to the job duties. So if you are working as a software developer, you would typically need to have a bachelor's degree in computer science or something similar to that. If you don't have that, you need to look into whether you can get an education plus experience evaluation that says you have the equivalent of a bachelor's degree in computer science or other appropriate field.
I can't read the name from Facebook. It's in a different language. Oh, it looks to be Reddy, R-E-D-D-Y. I can see that now a little bit. Can I legally stay here for more than unemployment on OPT, EAD? Can I be unemployed for more than 6 months? OPT, EAD? No, you cannot be. Now, having said that, Mr. Reddy or Mr. Reddy, is that if you are getting training, even if you are not getting paid, it will be considered as an employment for the purpose of the OPT EAD. So training is considered as employment in OPT. It may not be considered in the STEM extension, but when it comes to OPT EAD, a proper training in the relevant field for which you graduated will be considered as a proper employment.
Lost the question, but someone was asking for any update on the H-4 EAD premium processing. No updates on that. No action has been taken. It does have to be done through a regulation, which I would expect the Trump administration is going to drag its feet on. So we'll have to wait for a Biden administration on that.
Does a compelling circumstances EAD person, can he apply for advance parole? No, he cannot apply for advance parole. I'm assuming that you're speaking about compelling circumstances I-140 EAD. No, they cannot apply for the advance parole.
Govinda from YouTube wants to know if there's a way to check the case status for the receipt number so that you can see all of the past case statuses. That drives me crazy with the USCIS website that you only get the most recent case status. But if you create an account, a My USCIS account, I do believe you'll be able to see the whole history of the case.
A lot of people are asking questions that if the priority date backlogs, can I still get the EAD and AP approvals, advance parole? Yes, even if the priority date backlogs, you will get your EAD, you should get your EAD and AP approvals.
Janelle from YouTube wants to know if an EB2 physical therapist, which is Schedule A, can do a downgrade to EB3.
I need to know the answer to him.
Nobody knows the answer to this because
Didn't you file one
I
case?
did file one. I made some creative arguments that I hope will work, but yeah, we don't have any guidance that suggests it is possible, but we also don't have any guidance that suggests that it's not possible. So if you do proceed with it, just know going in that there's a possibility that it might not work.
What's the technical reason why it cannot be downgraded, Emily?
Well, because the labor certification is not actually done through the Labor Department. You submit a labor certification with the I-140 and ask the USCIS to certify it. So when you are doing the downgrade, is that labor certification and prevailing wage that you submitted 5-10 years ago valid to just resubmit with a new I-140 petition when it's not actually certified?
So if you were to get the prevailing wage again and do the labor again though, I mean, labor doesn't mean that you have to file with the labor certification, then it's fine, but using the old labor is where you feel a problem.
Right.
Okay.
So that would delay your ability to file that downgrade by probably at least 6 months to get the new prevailing wage, do the posting notice, and then file.
I would suggest people to take a risk and file it, and then probably have parallelly going one other prevailing wage so that they can, rely on that if needed, though. What would you suggest if you were to file a physical therapist right now? When you get the prevailing wage and you're filing, would you suggest to file in both categories?
I think I would.
Okay.
That's the best opportunity to get it done without having to do a whole lot of extra work.
For all the people, though, who are going to file the I-140 application, though, if your priority date is somewhere nearby, if you're in 2016, 2017, or even 2018, if you're filing the labor certification and filing an I-140 and putting the date, it may be worth for you to have both I-140s filed at the same time, because then you will be able to use it, because when things come in like the way they came in October, you don't have to worry about filing, getting the approvals. You can have both approvals, you can use whichever. And for filing EB2 and EB3, you can use the same labor certification. Assuming that labor certification is done for the purpose of EB2, you can use it for both purposes. Anything else, Amy?
I think that's about it for today. Thank you for joining us. If we were not able to get to your question, remember we do have a free daily conference call. And if you'd like to discuss your specific situation, you can always set up a consultation appointment with us or any of our attorneys by going to rnlawgroup.com.
Thank you, guys. Don't forget that if you want to speak, if we can cover these many topics, imagine if you make a consultation, we can cover all your things pretty soon, pretty quickly. Go to rnlawgroup.com and the consultations, you can make an appointment with us or anybody else, well-qualified lawyers in our office, you can make an appointment. Thank you very much.